So that's the parole evidence rule. Let's review. First, we determine whether a contract is a partial or a complete integration. The existence of a merger clause or an integration clause is very good evidence of integration, although it's not always dispositive. Formalist courts take an objective approach that almost always finds a merger clause evidences a complete integration. But anti-formalist courts take a subjective approach and admit extrinsic evidence to determine whether the parties intended the contract to be complete and exclusive. If a written agreement is final or partially integrated, it bars modification of written terms. If a written agreement is complete and exclusive or completely integrated, it also bars additional terms. Evidence that shows the meaning of ambiguous terms is not barred by the parole evidence rule. The parole evidence rule does not apply to ambiguous terms, only to clear ones. Evidence of course of performance, course of dealing, and uses of trade is also admissible to show the meaning of terms, even ones that are patently unambiguous, at least where a contract is governed by the Uniform Commercial Code. Evidence of subsequent modification is not barred by the parole evidence rule, although it is subject to the pre-existing duty rule. Evidence of a collateral agreement is not barred by the parole evidence rule either, but it can be hard to distinguish what makes something collateral versus expected to be part of a written agreement. And evidence of problems with contract formation is also not barred by the parole evidence rule. If the contract was not formed, any merger clause in it would not be binding. So now you know about the interpretation of express contract terms. Thanks for tuning in, and keep contracting.